Good afternoon, everybody. Welcome to another one of our LEASE podcasts. My name is Richard Hand. I'm a senior advisor and solicitor here at LEASE, and I'm very privileged to be joined today by Ricardo Calzavara, a barrister from Arden Chambers. Today we will be discussing Airbnb as it relates to leaseholders. Ricardo is particularly well placed as he's a specialist in landlord and tenant law and has written several articles on Airbnb over the summer. So let's start off, Ricardo, with an obvious question. What exactly is Airbnb?
Hi Richard. Well, it describes itself as a trusted community marketplace, and what it seems to do is allow those with access to accommodation, whether they're landlords or tenants in their own right, to offer their properties to basically anyone for short stays. It advertises or claims to advertise 2 million properties, including 1,500 castles, in 34,000 cities across the world. So that's a pretty big presence.
Yeah, it sounds like a major player in that sphere. Well, that sounds good. Now, I've got a spare room in my flat. I'd like to rent it out on a short-term basis. Are there any issues I'd need to be aware of before doing that?
Yes, in short, but as always in these matters, it depends on the tenure, so it depends on how you hold the property. I presume that most people listening to this will be long lessees, so I'll address their sorts of concerns. The first thing lawyers practicing in this field will always say is check the lease. I can't overstate the importance of that. It's a contract and it regulates the use of the property. So read it, and if you don't understand it, seek advice. I'm sure the Leasehold Advisory Service will be happy to receive your call.
We would.
The lease probably contains covenants restricting alienation, so that's things like don't sublet part, don't sublet the whole. It also probably contains restrictions on business use and the type of occupation. The words you're looking for are only a single family, for example. In your circumstances, you could be in breach of any of those, so I'd implore you to check with your landlord in advance. And in the background, there might be other clauses, other covenants against, for example, causing a nuisance or annoyance or inconvenience to the landlord or other lessees or other occupiers, allowing loud music to be played, or illegal and immoral use. They might be relevant. It's not quite so obvious.
Thank you. Yes, I am a leaseholder, so, I do have a freeholder, I've got a lease, and it looks like I'm going to need the freeholder's consent. So how would I go about getting that?
Well, the first thing to do is to check who you need to ask for consent. In some circumstances, it will be the freeholder, which is easy enough. In other circumstances, it could be the managing agent, a management company, a right to manage company. If you're confused, there'll be someone you can ask, and hopefully someone will be able to point you in the right direction. You want to set out that you want prior written consent, or a waiver from the covenant if there is one, or a license to license part or the whole of the property. It's better not to put the property on Airbnb without it. In some cases, the first tier tribunal, the FTT, has found that it was enough that the property was advertised and the landlord didn't have to prove that it had in fact been occupied under a short-term letting or license agreement. This is one of the circumstances in which it's not better to ask for forgiveness after the event than to ask for consent before the event.
Okay. Now, I've had problems communicating with the freeholder before, and I could ask his permission, but, it could take ages. I'm minded to just go ahead quietly, let my room without asking. If I did that, what would be the consequences?
Well, there are a few, I'm afraid to say. If it's a breach of covenant, you face problems. You're susceptible in the first instance to a claim for damages, but more problematically, you might face a claim for forfeiture. That's where the landlord first gets a determination that you've been in breach or are in breach of covenant, and then secondly, presuming that it's residential property, which it will be, gets a possession order to re-enter the property. Now, if that happens, you lose everything, which is fairly draconian, as the courts have recognised. So because of that, they lean towards waiver of forfeiture, but they'll require you, in almost every instance, to pay the landlord's costs, which by then could be substantial, and to remedy the breach. As I mentioned a moment ago, there are a few decisions of the FTT, the first tier tribunal, and there's one very recent decision of the upper tribunal which help us to understand the consequences. The first is Sarum Properties Limited and Jones, which is a case that was decided in March last year and involving an applicant freeholder and 13 respondent leaseholders. Their leases provided in identical terms that they mustn't sublet part under any circumstances, mustn't sublet the whole without the permission of the freeholder in that case, mustn't use the property other than for a private residence, and by the same token mustn't use it for business purposes, and finally mustn't void the insurance. The facts were that some of the flats were let on assured short-hold tenancies, and others were let on a short-term lettings website, which wasn't Airbnb, but it applies identically. The FTT held that the short lets were akin to hotel use, so there was no breach of the subletting covenant. It held something different in relation to the ASTs, but that's probably not relevant for the circumstances that we're discussing. And also held that on the fact there was a breach of the insurance covenant and a breach of the user covenants. Those are all fairly serious breaches to have found. We don't know what happened afterwards, whether the landlord sought to forfeit the lease. Another case which is similar is Laxcon Developments Limited and St John Guy Rogers, which was also last year, June. There was an applicant freeholder and one respondent leaseholder of a 3-bedroom penthouse in SW2. There were similar clauses to the ones I've just mentioned, and additional clause relating to, an additional covenant really, relating to not causing a nuisance. The facts of that case were a bit different. Rather than going away and letting other people in, St John Guy Rogers stayed in occupation and licensed some of the rooms he had on Airbnb and, if I remember correctly, also to film companies to record videos on the roof. The FTT again held there was no breach of the sublet covenants in relation to those licenses on Airbnb because there was no exclusivity of possession, but it found that there was a breach of the user covenant and of the nuisance covenant. Now, as your listeners will know, decisions of the FTT aren't binding, which is what's excited everyone about this new decision from the upper tribunal, Nemakova and Fairfield Rents Limited. The question in that case for the upper tribunal was whether granting a series of short lets was a breach of the covenant for use only as a private residence. Now, I emphasise a private residence because that's the basis on which the court came to its conclusions. Unfortunately, at least in my opinion, it hasn't particularly clarified the circumstances of Airbnb lettings or Airbnb licenses more than it's clarified the circumstances in which the lease contains that particular covenant. So the court emphasised rightly that the lease is the important thing to consider. It held that because there was no covenant against alienation, so that's the covenant I mentioned earlier, one that says don't sublet part, don't sublet the whole, or something similar, anyone could occupy it as a private residence. Whether someone was occupying it as a private residence was to be determined by reference to whether there was any sharing and the length of the occupation. The judge held that days or weeks would be too little to make it a private residence. Now that is probably an important finding that would apply in other cases. Whether rent was paid, though, was an irrelevant consideration. Miss Nemakova was in breach. And as I've said, the point of determining that there's been a breach is that the landlord might forfeit or seek to forfeit it. So that's a long way of saying, yes, there are pretty serious consequences.
Thank you, Ricardo, for going through the case law there. It does sound like I definitely want to get consent in advance. One other query I had is my flat's in London. Would I have any particular problems letting here as opposed to elsewhere in the UK?
Well, as with many things, London's a bit special. Wherever you are in the country, you need planning permission if you develop, and development includes a material change of use. Since 1973, in London only, the use of residential premises, and that's important, not commercial premises, as temporary sleeping accommodation, which is defined in the relevant act as anyone paying to sleep in the property for less than 22 consecutive nights amounts to a material change of use, and therefore you need planning permission. If you don't have planning permission, you're in breach of planning control, and the consequence is that the local authority can serve enforcement notice. Failure to comply with an enforcement notice is a criminal offence. That was changed last year by the Deregulation Act. It's no longer a breach of planning control if property is let as temporary sleeping accommodation for less than 90 days in a year, so long as the person letting it remains liable to pay council tax throughout the term. Landlords should be aware, though, because local authorities can exclude the effect of that provision, which is section 44 for the more conscientious that want to look it up. And if it's used as temporary sleeping accommodation for longer than 90 days, the whole period is a breach, not just the overlap.
Okay, thank you. All right, so let's say I've now got my landlord's consent and I'm not going to be letting a room for more than a few weeks, so won't fall foul of the 90-day rule you mentioned. Ready to advertise on Airbnb. Is there anything else I need to watch out for before I proceed?
As with my answers to all of your questions, there are a number of things you want to watch out for. The first is that you go from being a lessee to being a landlord. As long as it's a licence, there's no deposit protection requirement under the Housing Act 2004, and there's no need for a Section 21 notice under the same Act. But you may need a gas safety certificate, you may need smoke and carbon monoxide alarms, and you may need energy performance certificates. Those are all things that landlords have to deal with, and therefore, in my experience, lessees are unlikely to know, unless they've been advised by someone who does know, that those things are relevant. More worryingly, although mandatory licensing likely won't apply for houses in multiple occupation, because the people occupying the property are unlikely, but not necessarily unlikely to be occupying it as their only or principal home, you might, though, find that you need selective or additional licence, depending on local designations. You must check with your local authority before you do any such licensing to find out whether it would be in breach of those schemes, and if so, apply for that licence in advance. From this tax year, so 2016-17, there's a rent-a-room tax-free entitlement of £7,500, and from 2017-18, any property-related income up to £1,000 is proposed to be tax-free, so lessee landlords should talk to their accountant. And finally, they should check their mortgage conditions. The most serious consequence of breach of a mortgage is foreclosure. Less serious, possibly, is that most lessees who don't have a buy-to-let mortgage will find that they're in breach of the conditions in that respect and might be forced to pay the higher, or normally higher, buy-to-let rate. They should check those mortgage conditions and see if that's something they should be concerned about. Okay,
thank you. Before we finish, could you just sum up the main issues that arise then from leaseholder wanting to let on Airbnb that we've gone through today?
This may be a controversial thing to say, but I think it's a great website and it's got great potential. It's managed to attract a lot of media interest, a lot of media attention, and it claims to have had 60 million guests, which is absolutely enormous by any standard. For leaseholders, it's a good source of extra income for their spare room, or if they're lucky enough, their spare flat. However, they should make sure, before they use it, that they're not going to be in breach of their lease. If they think they might, they should seek consent in advance, and if they don't, they should be alive to the fact that they might be found in breach, may be liable for damages, and more problematically, may find themselves responding to a claim for forfeiture. As I've already said, the worst case scenario in those circumstances is they may lose their home. If they're in London, there are further matters they should consider so they don't commit a crime. I understand that Westminster and Kensington and Chelsea are starting to pursue landlords in their area who are letting their property on a short-term basis for more than 90 days. And that sort of thing will only, in my opinion, become more common. But wherever they are, these lessee landlords need to start thinking like landlords, and they should take advice, whether from a local estate agent or otherwise, or a lawyer indeed, on the things that they have to or might have to do before starting on what is a very different type of relationship with their property and the people that occupy it.
Thank you very much, Ricardo, for that comprehensive guide to Airbnb. And that brings us to the end of our podcast. I hope you enjoyed it. Thank you.